Okay, so there were some more arguments. Listen, I'm going to bring on our guest because he's special knowledge, great legal analyst across the spectrum of national media, Phil Holloway. He's going to be joining me. He's from the Holloway Group in Atlanta, Georgia, does criminal defense, prolific amount of cases, thousands of them. And as I indicated, he's a national TV legal analyst with networks like CNN, Fox News, NBC, HLN, to name a few. He's a super lawyer, has the distinction of a 10 rating. That's the highest rating you can get on Avo. And you were on Up and Vanished, which actually commenting a lot on the Ryan Duke case. Phil, welcome to the show.
Thanks so much for having me. I really appreciate it. And there's certainly a lot to digest here. So I guess let's get to unpacking.
Yeah, so listen, you know, I love the questions that our chatters in the chat room on the lawandcrime.com network. Again, Dan Abrams' production. They have great questions. They're like a jury in my mind. They've been really, really knocking it dead with regard to some of the questions. And Fighter for TA was asking a question about this change of venue. Phil, I know that you believe the change of venue and the statute of limitations are probably the biggest motions out of all of them filed. But let's talk a little bit about it. Fighter for TA says, Bob, can you explain the legalities of moving a trial from one county to another? How does it affect who the sitting judge is? So maybe you can give us a little breakdown on the change of venue, why you think it's so important, and answer Fighter for TA's question.
That's an excellent question. And so what we need to do is start with the idea, and really everybody needs to understand that Irwin County is not just small, it's really, really, really small. And so everybody there who lives there has been probably personally impacted by Tara Grinstead's death, okay? One way or another, they've been impacted probably on a personal level, possibly by someone they know, you know, is directly involved in the case. It could be that she was related to them. It could be that someone on the defense team, the prosecution team is related, somebody in law enforcement is related. It's a really small, close-knit community. So it's really not likely that you could get a jury that it has not been personally impacted by this. So this is the case of all cases that if everyone needed to be transferred, it's this one, even to the point that the district attorney doesn't even contest that it needs to be moved. Now, what this means is, as a practical matter, is that it's like picking up a circus and moving it on the road. All the players remain the same. It's just that the audience, or in this case, the jury, would be different. So you'd have the same prosecutor, you'd have the same district attorney, you'd have the same judge, you'd have everybody the same, except they would just move it to another jurisdiction in Georgia. And the law says that it must be essentially someone or some place that has a similar demographics to Irwin County. You know, that could really be anywhere, and you really don't have to go far outside of the metropolitan Atlanta area to find counties that are very rural and that might actually fit the bill.
Yeah, Phil, listen, I think just to give a little backdrop here, this case was cold case for 12 years. And like you said, it was a small community. It was greatly affected by this. And then this Up and Vanished series from Payne Lindsay started as a podcast, and it brought new attention to this. You've been on that podcast, as I understand it, a number of times. And if I have this right, there are something like 150 million downloads, to get to your point about how deep this has been in the fabric of this community. Can you give us a little more flavor and texture as to whether or not the community was actually participating in the podcast as you were commenting on them and they were trying to solve this case?
Yes, they were. And we know that going back to the early days of the internet and online chat rooms, even before the podcast itself, there was lots of public discourse. This was the type of stuff that was discussed around the coffee table, or discussed around the breakfast counter, the lunch counters at work. From the time this happened all the way up until, the arrests, and even today, this is the type of conversation that permeates the local community there. The podcast itself actually helped invigorate that public discussion as well. So you add that to it, and all of this put together just creates the necessity. Really, it's the perfect example of cases that really should be moved, because every side is entitled to a fair trial. You know, the defendant has a constitutional right in Georgia to have his trial in the county where the crime is alleged to have taken place. So unless the defendant actually waives that right, it can't be moved. But in order to get a fair trial, they've made the determination that it has to be moved, and the DA is not even objecting to it. I think there's probably going to be a lot of discussion and some disagreement over where it's going to be moved to. Each side's going to want it moved to, I think, different places. The district attorney may want it to be somewhere a little closer to home. Where the media markets are, that's going to be part of the calculus that the judge is going to have to go through. But at the end of the day, the judge is going to have to make a determination of, first off, where would be a good place, and then they have to decide, is that other jurisdiction willing to accommodate this this big trial coming in from somewhere else.
Yep, Phil, thank you for that very detailed explanation. And you are right, Fighter, for TA. In essence, you're barring a courthouse, you're barring a jury pool. But we all know as trial lawyers that whatever county you're in can have a dramatic difference in terms of who those jurors are. And I think that's what Phil is saying is going to be the fight. Each one wants to get the edge in the better jury pool for whatever side they're on. We got to go to break. We'll be right back. All right, so there's more rebuttal on whether the use of the word murder. We're going to get to that in a minute on the Ryan Duke case. Phil, I want to go back to that venue question. You're from Georgia. You know this case probably better than anybody, having commented it and followed it for so long. In my experience, I'm going to give you an example. I grew up in a place called Essex County, New Jersey, and the jury pools there tended to be really antithetical to the prosecution, really put them to their test, more of an urban environment. Whereas you cross a borderline back to Morris County, New Jersey, where I actually was the county prosecutor, is a very conservative, completely different space. And when lawyers could, they would rather the case be in Essex than Morris. So tell me, if you were defending him, what county would you want this to be in? And do you know this judge?
Yeah, I agree with all that, and they are a lot more, I would say, for lack of a better word, conservative, at least in the criminal justice arena, when you really get much outside the metropolitan Atlanta area. But you're not going to be able to keep this case in a large county like the metropolitan Atlanta area because of the saturation of the media market. So if I could handpick the county, and if I were defending it, I would probably look to a county maybe in northeast Georgia, northwest Georgia that's more rural. It's going to have to be a county that has similar demographics to this. Yes, I know Judge Reinhardt quite well. I used to work in his law office before he was before I was a lawyer. I was waiting on my bar results. I called myself a para-lawyer back at the time, and I worked in the law firm when Bill Reinhardt was a young practicing lawyer. So I've known him my whole life. I'm from that area. I used to be a part-time police officer in Ocilla when I was working full-time somewhere else. So I know the jurisdiction very well. I can tell you that Judge Reinhardt has his hands full, but I do believe that he's going to be fair. He's going to try to balance the equities of both sides and their arguments. And I think he's going to reach the right conclusions for the most part on this. Of course, balls and strikes, as judges are supposed to call things. Sometimes it's in the eye of the beholder. He may get some things right. He may get some things wrong, but in the end, I think he's going to do a great job. Yeah, well, you know, Phil, I think what we're saying in its basic part is that the difference of a jury from one place to another can be the difference between a guilty verdict and a not guilty verdict. I really want to emphasize, I see you shaking your head to the audience and the people in the chat room. Did you hear what I said? Depending on where it is, could substantially make a difference between guilty and not guilty. And that's always been something that's vexed me, whether I've been a prosecutor or a defense attorney. Going to break. We'll be right back. All right, motions in the Ryan Duke case. Phil, real quick, because we got a lot of ground to cover here. What is this all about with regard to use of the word murder and the motion that we just heard about the language in the indictment? Okay, so in Georgia, we see this a lot actually in rape cases, more so than murder cases, but there is some statutory authority that, you know, it's really the province of the jury to decide whether or not something is a murder. It's a legal conclusion. And so what the defense is asking, he's not asking that the prosecutor not use the word murder at all, because it is listed in the indictment. And at some point, especially in closing arguments, the prosecutor will ask the jury to find him guilty of murder. So she's not saying you can't use the word murder. She just don't want witnesses blurting out Ryan Duke murdered Tara Grinstead in that context, doesn't want the prosecution to elicit answers that require the use of the legal conclusion of the word murder. So this is not exactly a far-fetched ask by the defense. It happens fairly regularly. It's really a matter of discretion, but I do think there's a legal basis for it, and it makes sense to go ahead and ask the judge to restrict their use of it.
Right, and the defense also asked in another part I was listening to this morning that the judge not read the indictment to the jury, which is done, at least where I practice, all the time, because they were arguing that the grand jury only establishes probable cause or prima facie case to go forward, that the defense did not have an opportunity to present evidence, witnesses weren't cross-examined, and that by the judge reading it, the judge would kind of be giving like an imprimatur or an approval of it, and that they thought that the judge should not read the charges in the indictment. Have you seen that motion before?
Yes, I have. And it is discretionary by the judge. And see, I've been a prosecutor and defense counsel, and I can tell you from my own experience, it is typically read to the jury before the trial starts, even before jury selection is complete. But as a prosecutor, I remember thinking, okay, when the judge is reading this grisly indictment, that's helping me as the prosecutor. It's planting the seed in the jury's mind that regardless of the burden of proof, this person sitting at the defense table is probably guilty of something. On the other hand, as defense counsel, I can understand why, because sometimes I cringe when this nasty indictment is being read to this jury before they've heard any evidence. And so what the defense is saying is, look, Judge, let's just take that out of the equation. At some point, the judge is going to have to read the indictment, but he doesn't have to do it before jury selection. He doesn't have to do it before any evidence is heard. He only has to do it before the jury goes back to reach its decision. And so the defense is trying to say, let's just take that out of the equation so the jury's not tainted by the reading of the indictment before the trial starts.
Okay, so again, in this Tara Grinstead case, who's the victim of this matter, this was a cold case for 12 years, and there have been some fantastic motion practice going on here, some of it technical, but makes a big difference down the road. Phil, let me ask you, there's an argument here about the admissibility of statements that was made. Can you tell our viewers what statements we're talking about, and what was the argument by the defense vis-a-vis trying to get those statements excluded?
So in any case where a defendant makes statements, whether they're in custody or not, the burden of proof is on the state to prove that the statements were voluntarily made, and that if they were in custody, that it's not a violation of the Miranda rules, you know, that you have the right to remain silent warnings and all of that. In this particular case, we heard the prosecution stand up and say, look, we've got two witnesses out in the hall, they're ready to go, because it's their burden of proof, right? So they would have to call witnesses. But they also told the judge that he was not in custody when the statements were made. And they also told the judge that despite that there was some Miranda warnings. And there's been, let's just say, some inferences made, and some people in other places and in other arenas have alleged that there might be some question about whether any statements that Mr. Duke may have made were voluntary in the complete sense. So what we saw early on was the defense basically withdrew any objections to that, and it seems like they essentially stipulated that they were voluntary and that there was no issues of Miranda violations. And I would suspect that's a matter of pretrial strategy.
Do we know what those statements are exactly? Because at least when I'm reviewing this case and the materials have been given to me, you know, the state doesn't have a body, and they've got to have some sort of evidence. They made an arrest here. What kind of statements are we talking about exactly?
I think we can fairly assume that they were incriminating. I don't know that they necessarily would rise to the level of a full confession, but we really don't know. And I think that may be part of the strategy at this point, is to sort of keep that ball close to the vest, or keep that card close to the chest, so that the defense doesn't have to get into any of that right now. They probably are satisfied from what they know through pretrial discovery that if he made a statement that he was not technically in custody at the time, therefore Miranda would not apply. And they know from what they've been given whether or not, you know, the confession or the statements were voluntary. So they're not alleging that anybody beat any confession, you know, out of anybody, or anybody tortured anything, or that there was any promise of leniency. So the defense is basically, I think, making a strategy decision at this point. We're just not going to get into the statements at this point. We're going to save that for trial.
Yeah, those statements are going to be really, really huge depending on what they are, especially, again, like when I said you don't have a body, and who they made them to, when they made them to, and what was said is going to be very, very important. Great to have a case to break down with you, Phil, that knows this so well. All these motions have a huge difference. Of course, obviously, the admissibility of a statement of a defendant is a huge piece of evidence for the prosecution, and it looks like the statements, whatever they may be, are going to get in. We're going to go to a break. We'll be back on the other end. Stay with us. Thanks, Phil. All right, welcome back. Phil, this is a motion made by the defense. We heard the defense attorney arguing there for funds in order to get a private investigator. Now, every jurisdiction is a little bit different with this. In my jurisdiction, you as a private attorney can make an application to the public defender's office for investigative resources. It's reviewed by them because a person may be indigent. It seems like they really didn't know or care who pays for it. Is there a procedure in Georgia with respect to this kind of request as to who pays for it?
Yes, there's a very similar procedure to the one you just described. They're not really asking for a lot. I've seen the actual motion, and I think they capped the initial expenditure at $3,000 to $4,000. So in the whole scheme of things, they're not asking for a lot, and they do need an investigator. There's a ton of material here, and for legal reasons, lawyers, for example, can't be witnesses in a case. And so if a witness changes their statement in a courtroom from what they may have said to you or your investigator outside of the courtroom, you're going to need to be able to call a third party, i.e. an investigator, to rebut that. So that's why defense counsel needs an investigator. After all, the DA has their own investigators. They have all the law enforcement resources that are available to them. So they have plenty. The defense has none. Now, he is indigent. Nobody questions that. But basically, I saw the DA say, well, he had his opportunity to have a public defender, and he gave that up for these private attorneys. But the problem with that argument is that he has a right to his own counsel if he can choose one, and he chose someone else who happens to be doing this pro bono. So that really should not be an equation. Into the equation of what should matter is how does he get a fair trial? Right. Now, you shouldn't have to give up the investigative resources in order to take advantage of pro bono counsel of your own choosing. Right.
You know, Phil, I just recently had a case as a defense lawyer where we petitioned for resources on a very, very complex white-collar case with an indigent defendant. And the fact is that he paid for, or his family paid for our services, took it out of the public defender's expenses, if you will, by having us retained in the case. And it became a real difficulty, you know, for defendants to be able to get experts, to be able to have investigative resources. And listen, as the head county prosecutor, I had all those tools and resources. I asked for X and I got X plus. So there is an uneven playing field there. Let's listen to the state's argument against this, and we'll come back on the other end, Phil. Okay, welcome back. This is the Tara Grinstead case. Phil, I know you got to go. I got 3 quick questions I got to ask you. We got to hit it before we get to a real hard break there. One, the prosecutor is arguing against this. My question, it's only a couple of $1,000s. We talked about the inequality, if you were, in equities, that the state has so much resources at its disposal and he's indigent. I, as a prosecutor, just would not object to this because I think I'd be setting up an appeal that it was ineffective for his lawyers not to have investigators. Thoughts?
I agree with you 100%. I think this is something the DA should have just said, Judge, I'm going to leave that up to you. If they say they need an investigator, who are we to question that? I think it's something that they're creating potential appellate issues where they don't need to.
Yeah, you know, listen, Phil, thank you for that quick answer. You know, as a prosecutor, I used to tell my staff all the time, we are about winning not just a conviction, but it survives the sustainability of the appellate process, so you don't have to try a case again a second time where it gets weaker, put the victim's family through this. I think this motion is a little off base, but let's go to the personalities here because you know the people. This is why you've been an amazing guest. Tell me a little bit about, this is a district attorney, the head guy. I tried a murder case as the head guy. I was probably the first one or last one to do it in 30 years. It's a lot of pressure, a lot of heat. Who is he, and is it typical that the head guy handles cases in Georgia?
Well, in this jurisdiction, on a case like this, it doesn't surprise me at all that Paul Bowden, who's the elected DA himself, is handling the case. I've known him for my entire, I guess most of my life, at least since early childhood. He was the DA when I practiced in that circuit. He's partly responsible for my making it to Atlanta as a prosecutor because I think he gave me a good recommendation to the Cobb County DA when I came here in 2000. So the state's well represented. Ashley Merchant and I are friends, we're colleagues. Her office is not far from mine. We handle cases together as co-counsel. We've represented co-defendants together in some big trials, whether they be murder or other things. We've been co-counsel in murder cases. So I can tell you that both sides in this case are well represented. And the judge, he's going to do the very best he can do. So I think that all parts of this case have very good legal minds behind them.
Yeah, you know, you love when you see this because at the Law and Crime Network, we cover in cases gavel to gavel, and in some places you see some sloppy lawyering or judges that aren't really on the game. You can definitely tell if you're a skilled trial lawyer that every component in this courtroom are very skilled, and that's the way it should be in theory in order to try to get to the just result. All right, Phil, I know you got to go, but before you do, what's the biggest thing that we've got to look out for in this case, and what's your prediction? State got a strong case or not?
I think that the state has an uphill battle, in my legal opinion, with regard to some statute of limitations issues that we may see argued about today or tomorrow. Murder, however, does not have a statute of limitations in Georgia, so in that regard, they're safe. I think this is all going to depend on what statements were made and whether or not those statements match any other evidence and whether or not those statements are believable. And we might even see some issues of maybe a false confession aspect raised at trial. I don't know if that's going to be part of the defense. It's just sort of me reading the tea leaves here, but there's a lot to look out for.
Hey, listen, Phil, you have been amazing. You're not only an amazingly skilled trial lawyer and a great legal analyst, but you are right down there. You know the prosecutor. You know the defense attorneys. You know this case, having commented on it a lot. Please come back, and thank you so much for staying a little extra time. We're going to break. We'll be right back. Stay tuned.